Hey folks, this is immigration attorney Hassan Abdullah here from the San Francisco Bay Area, and I'm preparing this video to talk about the new RFEs that we're receiving in H1B cases relating to why wage level 1 may not be considered a proper wage level if you want to qualify computer programmers and other types of computer occupations as a specialty occupation. So lately we've been seeing these RFEs and it's targeting programmers in particular. So basically we'll go into what the RFE says, how to prevent this RFE, and what is the possible solution and way to deal with this RFE. So what does the RFE say? It starts off by saying that wage level 1 is defined by the Department of Labor as a level that's associated with a beginner's level qualification, and that the tasks for wage level 1 in any occupation is one where you are only going to exercise a limited judgment and you're going to receive instruction from a supervisor. They then point to the Occupational Outlook Handbook, which is something that is used by USCIS when evaluating if something qualifies as a specialty occupation. The specific section for computer programmers, that is, in the Occupational Outlook Handbook says that some employers only require an associate's degree. So USCIS has taken that verbiage and they're running with it now and saying that, well, because a computer programmer, some employers require an associate's degree, that means all entry-level computer programmer jobs are such that they're not going to qualify for H1B, because you don't need a bachelor's degree. And if you've selected wage level 1, that means you're saying that it's complete entry level. And if you're going to argue back and say, no, it's not, it's a little bit more complicated than entry level, then USCIS will say, well, if it's not entry level, then you have to select wage level 2. But that's not how wage levels work. So we need to argue back against USCIS about the way wage levels are determined. So the question is, why is this happening? Well, later in this video, I'm going to explain specifically how we can address this issue. But why is this happening? There's two things. One is there was an executive order that came out April 18th of this year, which is called the Buy American, Hire American executive order. And in the Hire American section of the executive order, there is the government is imploring DHS to basically create more rules and regulations to ensure the highest paid H1 workers are selected for H1B. That H1B is reserved for only the highest paid workers, and that American workers are not harmed. So that doesn't mean there's actually any new rules, but this is what's being encouraged. That's all. And then USCIS, actually before that, around the end of March, issued a memo saying that if you are going to go with a computer programmer occupation and you select wage level 1, just as these RFEs are now saying, wage level 1 means that it's entry level, and the Occupation Outlook Handbook says that some employers require an associate's degree. If it requires an associate's degree, it's not a specialty occupation requiring a bachelor's degree, therefore not qualified for H1B. And it's sort of a catch-22. Then you say, well, if you're going to argue that no, it's more complex, then USCIS is going to say, well, then you should have selected wage level 2. So why is that not correct? How can we handle this issue? The way to handle this issue is you need to argue that the way wage levels are calculated, if this is a computer programmer or similar type of computer occupation, wage level 1 can be associated with an employer requiring at least a bachelor's degree and up to 2 years of experience because of the way wage levels are calculated. Now, we're not going to go into the actual system and method of calculation in this video, but that's beyond the scope of the time we have. However, that's the argument that we can make. And another thing from there is we can argue that wage level 1 is appropriate, not just because it's requiring less than 2 years experience, but the Occupation Outlook Handbook also says that employers do normally require a bachelor's degree. So again, we are waiting to see how USCIS is actually going to deal with these cases, but that's basically the approach that's recommended. On top of that, the other question is, how do you avoid this altogether? Well, obviously very simple. Go with wage level 2 if you can. Now, if you can't go with wage level 2, maybe you want to try a different occupation. And that's where a good qualified attorney can help in allowing you to determine what's the most appropriate occupation. There's some occupations that are prone to RFEs on whether or not it's a specialty occupation. So anyhow, this is something that we should stand up to and defend clients about. It's not reasonable that USCIS is just creating some kind of new way of viewing these cases without actually having any law change in immigration. The whole point is H1B is not about testing the labor market first to see if there's qualified Americans for the job and only giving it to the highest paid workers. It's about also people who've graduated, they've studied here, there should be some incentive to come here and study. And H1B is one of those incentives and should continue to be one of those incentives. So we don't want this to be taken away, so that's why we're going to fight against these RFEs, and hopefully we will prevail, and USCIS will hopefully scale back on these type of RFEs because they are not reasonable and they're not supported by regulations. So with that said, thank you for watching this video. Hopefully this has been helpful to you. Bye for now.